Evicting a tenant can seem like a complicated process, but in this video, we'll quickly explain eviction laws in Alaska and how to recover your property in 6 simple steps. First, what is an eviction? Eviction is the process of legally removing a tenant. It's illegal for a landlord to change locks or physically remove a tenant themselves. So, if the renter refuses to leave after violating their lease, you must seek an eviction from the court. The process for simply terminating a lease differs from that of an eviction. Lease terminations require proper notice from the landlord or tenant, and state requirements can be found on our website. Legal reasons for eviction in Alaska. A landlord only has grounds to evict a tenant for reasons allowable in the state. The first step in the eviction process is to give the lessee one of the following notices. Substantial damage to the premises. If the tenant purposely inflicts severe damage to your property, you can issue a 24-hour notice to quit. After receiving the notice, the tenant must vacate within 24 hours and has no option to cure. Illegal activity. If the tenant is engaging in illegal activity, you can serve a 5-day notice to quit. This gives the tenant 5 days to vacate the property with no ability to cure. Non-payment. For instances of late rent, you can serve the tenant a 7-day notice to pay or quit, which gives them 7 days to pay the rent in full along with any penalties, or vacate the property. Non-compliance. If the tenant violates the lease, this notice to comply or quit gives the tenant 10 days to either comply with the lease or vacate the property. If the tenant commits the same violation within 6 months, you may instead serve them a 5-day notice. Rent grace period. In Alaska, there is no rent grace period. Rent is due on the due date. An eviction notice can be served if the rent is only 1 day late. 6 steps to legally evicting a tenant in Alaska. Serve the notice to quit. Choose the form you need and download or fill it out on eForms.com. Post it on the tenant's door and also send it via certified mail with a return receipt requested via USPS. If the breach is curable, you must wait for the specified number of days to give the tenant a chance to fix the problem. File eviction papers with the court. If the tenant hasn't amended the issue and is still on the property, you now need to file a form CIV 730 complaint with the district court in your area. The following must also be filed with the complaint: case description, judgment for possession, service instructions, summons, and writ of assistance. Send documents to the defendant. After the filing, the landlord will need to use a process server to serve the tenant a copy of the complaint and summons. After the tenant has been served, they'll need to file a form called a return of service that will be sent to the landlord and the court. The tenant also has 20 days to file an answer with the court. Attend the hearing. Now the court will schedule a hearing where both parties are expected to appear. If the judge rules in your favor, they will grant you possession of the property. Removing the tenant. If the tenant is ordered by the court to leave and they don't vacate, you may call your local sheriff's department to remove the tenant and their possessions. Collecting past due rent and court fees. The court will typically automatically set an additional trial hearing for damages. If not, you'll need to file a memorandum to set civil case for trial. Now you can get eviction proceedings started. Get eviction forms, court documents, and all other information you'll need at the link below for free.